Okay, welcome to this afternoon's session of the Kansas Court of Appeals. We are here today on the case 123406, Debbie L. Gerlach versus Choices Network and QBE Insurance Corporation and the Kansas Workers' Compensation Fund. Before we get started, I've introduced myself. I'm Karen Arnoldberger, Chief Judge of the Court of Appeals. I'll be presiding over this hearing, which just means I'll be the timekeeper. To my right is Judge Henry Green, the longest serving member of our court at 28 years. To my left is Judge Michael Boozer, been on our court for 16 years now. So we will be the panel deciding this case. Because this is going to be recorded and people may pick up to watch this that don't know much about the case, the appellant, I will give you an extra couple minutes at the beginning of your argument to just summarize very briefly what this case is about for someone watching that wouldn't know anything about it. And I won't count that against your time. So with that, would the parties please state their appearances, please?
The appellant Choices Network and its workers' compensation insurance carrier QBE appear through counsel Ryan Welts, and may it please the court.
Okay.
Debbie Gerlach, the claimant and appellee is represented by Jan L. Fisher. May it please the court.
Okay.
May it please the court, Matthew R. Bergman appears on behalf of the appellee Kansas Insurance Fund.
Okay, so how were we planning on oral argument on this? We have two appellees. Let me get the case here. Okay, this has to do with an extension. So were there briefs, but did the fund file a brief?
It did.
As well? Okay, I should know that. I'm at a little loss as to how we do time here since we have two separate appellees.
If it would please the court, my argument should be relatively brief because on the first issue, the fund has very little involvement. There is a collateral issue, which the fund may take 2 minutes to comment on or something of that nature.
Judge Boozer, did you have something some guidance you were about to give me?
It pleased the court. I was just going to suggest that the two appellees might want to get together and see how they want to split their time.
That's how we would typically do it.
We actually discussed that yesterday, and
okay.
we'll do it 50-50. But I don't think either one of us is going to take that time.
Okay, great. Well, thank you. I won't be confused anymore then. So the appellant will go first. And did you wish to reserve any time, Mr. Welts?
Yes, Your Honor. If I could reserve 3 minutes for rebuttal,
Okay.
That would be great.
All right. You may begin at any time. And like I said, you'll get an extra 2 minutes to just give an overview of this case.
Okay. Thank you, Judge. And again, may it please the court, thank you for entertaining oral argument on this matter. This is a workers' compensation case. It arises out of a work injury that was sustained by the claimant and appellee, Debbie Gerlach. Ms. Gerlach sustained a fall, and it went to a preliminary hearing on benefits. We ended up with an order for an examination by neutral medical examiners, Dr. Satterley for a shoulder injury and Dr. Lowry Jones for an alleged knee injury. Treatment commenced for the shoulder injury with Dr. Satterley over time. The case involves a request for dismissal under KSA 44523F subsection 1, which contains a requirement that a case proceed to regular hearing, settlement, or an agreed award within 3 years of the date of the filing of the E1 application for hearing. And that's the pleading that starts the process off formally in a workers' compensation claim. I think that may be enough background off time, Judge, and if it would please,
Yes, that's fine.
we can start my time. And a lot of my time today may have kind of a bleed over into some of that background information, but to pick it up from there. So Dr. Satterley did identify a work-related injury to Ms. Gerlach's shoulder. There was a significant amount of medical treatment that was paid, and she remained under authorized care with Dr. Satterley for quite a while. So this isn't a case where we were making any kind of allegation that the case was, dying on the vine and not being prosecuted or anything like that. Ms. Fisher, who represented and represents Ms. Gerlach in the matter, anticipated that the medical treatment on an authorized basis could extend past the 3-year date provided for under KSA 44-523. And in anticipating that, she filed a motion to extend the time for that. And so the statute provides that if that motion is filed within that 3 years, and the basis for the motion is that the claimant has failed to reach maximum medical improvement, then the deadline is extended as a matter of course. And because Ms. Fisher's motion was timely, and because I knew the allegation that the claimant had not reached maximum medical improvement to be true, because we were authorizing that care, we didn't contest that motion. And what occurred afterward was that Ms. Fisher circulated an agreed order to provide an additional 6 months from the 3-year anniversary date of the filing of the E1 application for hearing, and that would extend her deadline into, it was November 29, 2018 was the date of the deadline extension that the parties signed, and that was signed off by Administrative Law Judge Moore, who had the original jurisdiction over it. November 29, 2018 came and went, and there were no additional motions to extend that deadline. I myself failed to calendar that date. I think, just knowing Ms. Fisher to be a very good and conscientious litigator, I assumed that there would be another extension filed if she needed one, but that didn't happen. And so a few months after that agreed upon deadline had passed, Judge Moore took it upon himself to advise the parties that, hey, this deadline has come and gone. Has the case settled, or what's the status? And Ms. Fisher advised the court that the claimant still had not reached maximum medical improvement, and that was true. And Ms. Fisher indicated that she was going to circulate an additional order for extension of time. The circumstances were different for us, being the employer and the insurer at that point, because the original deadline had lapsed, and now my client felt like it was in a position to challenge whether that deadline extension should be granted, because we know from what has happened with the appellate decisions on the Glaze versus J.K. Williams matter, that those good cause arguments about a person not reaching maximum medical improvement or any other good cause arguments are only deliverable to the court's discretion when either you're within the first 3 years of the E1, or if there's been a timely motion to extend the claim. And so because there had been a lapse of that deadline, we filed a motion to dismiss the claim for lack of prosecution, arguing that the deadline of November 29, 2018 operates with the same legal effect if it has failed to be heeded as the original deadline. So we had a motion hearing for the motion to the application for dismissal, and Judge Moore determined that when a timely motion is filed under 44-523-F1, he retains jurisdiction to continue to hear good cause arguments and to extend that deadline, even if the motion to take that action occurs outside of the deadline extension. We attempted to appeal that determination to the appeals board originally, but the appeals board took the position that the judge not dismissing the case isn't a final action. And so initially the appeal was determined to not be right. And so the case proceeded until Ms. Gerlach did reach maximum medical improvement. And
So do you agree that there, up until this point, there still was no maximum medical improvement? Is that disputed?
That is not disputed. At any point, so if a motion had been filed prior to and up to and including November 29, 2018, stating that the claimant had not reached maximum medical improvement, that would have been true, and that the operation of the statute would have required the judge to grant an additional extension. And frankly, if that motion had been filed within that time.
I understand what your legal argument is with regards to the statute. My question is factually, during all of this continuance of the case, was there still not, were we still awaiting maximum medical improvement?
We were. Maximum medical improvement didn't happen until later. But the argument that we've made along the way is that once that first lapse occurred, the judge was in error to have not dismissed the case originally on our initial application.
I understand that. I'm just asking factually whether there's any dispute that she still was not at maximum medical improvement.
That's true. There was never an opportunity.
So your motion to dismiss is a jurisdictional issue based on Glaze and the statute. You think that kicks her out of court on a statutory basis, but you would agree that as far as workers' comp coverage, she still was not at maximum medical improvement.
I do agree. It's a legal argument based on the judge losing jurisdiction. And that's kind of the point that we've made, is that that Judge Moore did not have jurisdiction to continue to extend over time. We continued to object to those, essentially saying that those were additional links in a chain that had already been broken. But we did not continue to appeal those because we knew the appeals board had already taken the position that that wasn't right. And we thought that that was an appropriate determination of the board anyway. The only reason we wanted to take that up to the board originally was to make sure that we had preserved the issue just in case they felt like they had jurisdiction over it. And we didn't want to feel, we didn't want to find out later that we had waived it.
And before Glaze and before the statutory change, was it a 5-year window, or was there no window? I can't remember.
Well, there is a little bit of history on the statute. So there used to be no provision at all. Then there was a 5-year that I think was implemented in 2006, and it didn't have any provision for any kind of hearing or anything like that. And I think that the hearing it was added when the time limit was shortened to address maybe some due process concerns on that. So that's what happened. And so it's been a 3-year statute since May 15 of 2011. Yeah. So in any event, we believe that Judge Moore and the board have kind of tortured the language of the statute, because to argue that a single deadline extension then gives the judge basically this plenary and continuing authority to grant extensions even in the absence of a timely motion for extension changes the nature of what is being asked, because the statute allows a claimant to request and the judge to grant, under certain circumstances, an extension of the deadline. But what Judge Moore has done is he's eliminated it to say, well, I can hear good cause reasons, for as long as I want, as long as there was that timely motion. I think it comes down to an issue of statutory interpretation. I believe this is a matter of first impression. Ms. Fisher has taken the position that the clear language of the statute doesn't contemplate the filing of multiple motions. The statute talks about a motion. But that argument, I think, is performatively dejustified by the fact that as soon as Judge Moore indicated that the November 29, 2018 deadline had passed, Ms. Fisher filed another motion and continued filing motions and asking for the court's approval to keep the case open and allow the case to proceed to regular hearing. And so I think it's inherent in the nature of requesting a deadline extension that you get a new deadline. And there's no authority that I am aware of in workers' compensation or in any other instance that when you take a deadline, and especially a jurisdictional deadline, and move it, that the consequences of not honoring that deadline change. And so that's the position that we've taken. We impled the workers' compensation fund at the point that we anticipated that there would be a request for reimbursement if we were successful in the dismissal. The latter part of that statute under 44.523F1 indicates that that a dismissal pursuant to that subsection counts as a final disposition of the claim for purposes of reimbursement under KSA 44.534. We introduced evidence at the regular hearing on the benefits that we had paid to date, with the belief that at some point, if we prevailed on the procedural issue, that we would need to have demonstrated what we paid for purposes of laying the predicate for a request for reimbursement from the fund. The fund and Mr. Bergman have taken the position that because this was a compensable claim, even if we went on the dismissal, they being the fund, would not be obligated to reimburse us. And I think that's a novel argument, and I don't think there's any support for that in the statute. The statute, the 44.523F1 was a specific and more recent statute than the reimbursement statutes, and the legislature specifically made dismissals pursuant to this subsection a final disposition for purposes of reimbursement. The fund is saying essentially that that the employer and the insurer in this case stipulated that there was a compensable accident, and that's not what the fund is meant to have to do, is reimburse situations where you have a compensable injury that was kicked out of court on a procedural default. But to kind of play the tape forward on that argument, that would mean that if you had a compensability defense as well as a procedural default, you wouldn't pursue the procedural default for fear that the fund might turn around and tell you that you're not entitled to reimbursement. And what we have at least divined in terms of the legislative history and intent behind this statute is to provide an easier mechanism for getting rid of stale cases. This one wasn't that. And I know that it wasn't, but the legislature did specifically make this type of dismissal and default something that the fund would be obligated to reimburse for. And I'd hate to put the cart before the horse on all of that, but there have been some decisions out of the Court of Appeals regarding the amount of proof that has to be put on to demonstrate, what was paid, so that the director can fulfill in this case, we have a male director right now, his ministerial act of certifying the reimbursement. And so that's why we put that evidence in, and we brought the fund on, as soon as we anticipated that we would be making that argument.
I think that's your time. Do the panel have any other questions? Mr. Welts, you'll still have your rebuttal time, 3 minutes rebuttal. Okay, Ms. Fisher, Mr. Bergman, who's going first?
I will.
Okay, so 7.5, is that what you want?
That's fine.
Okay.
I'm going to only speak to the issue concerning the interpretation of KSA 44.523F1. And that third sentence, that's very problematic, that I'm sure each of you have heard cases on. The administrative law judge may grant an extension for good cause shown, comma, which shall be conclusively presumed in the event that the claimant has not reached maximum medical improvement, comma, provided such motion to extend is filed prior to the 3-year limitation provided therein. The Supreme Court in Glaze versus J.K. Williams talks about that sentence extensively. And the essence of their decision is that when you take out the extraneous clause and its comma, the sentence says, the administrative law judge may grant an extension of time for good cause shown, provided such motion to extend is filed prior to the 3-year limitation provided therein. my case is not a Glaze case. I will be the first to admit, better practice would have been for me to have filed an extension before the original order expired. I did not do that. But the statute does not then deprive the administrative law judge of determining whether the claimant was at maximum medical improvement and whether there's good cause to further extend the time to get to regular hearing or settle the case. Unlike the Glaze decision and all of the other numerous decisions that have been to the Court of Appeals, I filed a motion to extension of time. The accident date's November 24th, 2014. The application for hearing was filed May 29th, 2015. The motion for extension of time was filed October 11th, 2018. So the agreed order to extend time was done for 6 months, and that's because that's Judge Moore's practice. And if you'll look at all of the extensions, you'll see they're each for 6 months. And we did the agreed order, and the order simply says we extend the time till November 29, 2018. There is no sanction in that order for failure to file another motion prior to that time. So the question is, does the plain language of the statute require the court to dismiss if there is not a supplemental motion? What the administrative law judge said, what the board said was, we've looked at the Glaze decision, we've looked at the plain language of the statute, we've looked at the admonitions from the appellate courts not to subtract or add language to a statute that is not there. And we find that the statute simply requires that a single motion, such motion, be filed. Ms. Fisher filed that motion. We're not deprived of jurisdiction. At that point, the administrative law judge had jurisdiction. And once he had jurisdiction, he could then decide whether another motion should be extended for good cause or because the person was not at maximum medical improvement. I feel like the place of Ryan, who actually argued the Glaze decision, is sort of flipped in this particular case, because in the Glaze case, Mr. Welch would argue over and over and over again, don't go beyond the language of the statute. Look at the plain and ordinary words of the statute. Well, what is he saying in this case? He's saying by implication, if you have to file one motion, then you have to file multiple motions as the extension goes on. Well, I'm sorry, but the Supreme Court has made very clear, we don't do that. We don't look at legislative intent. We look at the plain and ordinary language of the statute. We do not add language to the statute or subtract from the statute. And the statute says such motion, a motion. I would point out, if you look at the language of the statute, the argument that he's making is somewhat nonsensical, because the language of the statute says, in the last clause, provided such motion to extend is filed prior to the 3-year limitation provided herein. Well, what's the 3-year limitation provided herein? That's 3 years from the date you filed the application for hearing. Well, I filed the application for hearing May 29th, 2015, because I have to file that in order to get a preliminary hearing. Well, that means that I had to file the motion, any motion, by May 29th, 2018. Now, that's before the first extended order even is completed, because the first agreed order to extend time goes through November. So what he's saying is I had to file a second motion for extension of time 6 months before the order to extend time had even concluded. And now how I would know my claimant was not going to be at MMI and that I needed to file a second motion 6 months before, I have no idea. But I think, and again, I said this at the beginning, it's a very simple argument. The plain language says one motion, such motion. I have done that. I've complied with it. There's no other issue in the case concerning good cause or maximum medical improvement. The judge kept jurisdiction, and he was appropriate therefore to keep the case open.
Thank you.
That's all I have.
Any questions? Okay, Mr. Bergman, tell us why if Mr. Welts is successful, why the fund should not pay for Ms. Gerlach's medical treatment.
Your Honor, thank you. Both the trial court and the Workers' Compensation Appeals Board found the issue involving the fund moot because it had sided with Ms. Fisher's client. And similarly, if this court would do so, I think the result may very well be the same. However, if the court were to reverse the prior decision of the Work Comp Appeals Board, it is likely that this matter should be remanded back to the lower courts for further analysis and hearing. I do not agree. I do not argue with Mr. Welts in the fact that the language of 44-523-F1 does indicate that a dismissal can be considered a final disposition at full hearing of a claim. But I would add that the language of that statute indicates that the same must be pursuant to KSA 44-534A. And the position of the fund is that with the presence of 44-534A in 44-523, there are additional conditions that are placed upon the respondent as to what they may or may not be able to seek reimbursement for. And specifically in our brief, and I italicized on page 6 of my brief, KSA 44-534A states, or A, and then parentheses B and parentheses says, for all amounts of compensation so paid which are in excess of the amount of compensation the employee is entitled to. And the fund raises the question about how to best interpret that language, the employee is entitled to. And expanding upon that argument, the position of the fund is that if Mr. Weltz's client wanted to deny compensability of this case, he could have done so all the way through the hearing. However, that did not occur. What occurred is that there was a stipulation that the claim was deemed compensable and the amounts that were paid as far as temporary total disability benefits and medical benefits to the claimant were confirmed by Mr. Welts. The only issue that was really taken forward by Mr. Welts was the dismissal under 44-523F. And the position of the fund is that the admission of compensability is an acknowledgement by the respondent that the claimant was entitled to those benefits. And if so, there appears to be a limitation within KSA 44-534A as to what the respondent can claim from the fund as far as reimbursement. I believe this is a matter of first impression. I could not locate any similar cases on it. I have read Mr. Weltz's brief and I understand his position. He may view our argument as novel, but I am trying to plainly read the statute. And I do not believe it is correct to interpret KSA 44-523F1 to indicate that the fund, quote, automatically has to pay the respondent. I think that the application of 44-534A is still in play because it places a condition on what type of reimbursement may occur. And that statute also provides the opportunity for a full hearing on the claim. And in summary and with absolute brevity, Your Honor, that is the position of the fund.
Any questions from the panel? Okay, Mr. Welts, you have 3 minutes.
Thank you, Judge. And again, may it please the court. Just addressing Mr. Bergman's argument regarding the stipulation of the compensability of the claim. Our argument here on the procedural default is that obviously has to be determined first. And here we didn't have a binding stipulation. Those are made at the pre-hearing settlement conference. So in a pre-hearing settlement conference happens after maximum medical improvement. So had the judge taken our position and dismissed the case for lack of prosecution, which we're arguing he should have done, then the stipulations would not have been made at a pre-hearing settlement conference because the case would have been dismissed. And the case wouldn't have proceeded to regular hearing because the case would have been dismissed. So I think the court first has to rule on the procedural and jurisdictional issue of whether the case ought to have been dismissed for lack of prosecution. And if it determines that that should have happened, then I suppose the timing of that matters. And that would mean that those stipulations and the regular hearing and everything else really was legally of no import. That those stipulations weren't made. We made the stipulation of a compensable injury at that point because the dismissal was the only point worth arguing. And it may not have escaped anybody's attention here, but the award in this case, once we subtracted out the temporary total disability benefits that had been paid, the permanency was only about another $800. And future medical wasn't sought. So there weren't very many benefits that came by virtue of the award. And then after the appeals board affirmed on the dismissal issue, Ms. Fisher made a demand for the payment of the permanency, and I didn't have any grounds to stay that during the pendency of the appeal, so everything has been paid out. But one last point on the dismissal. The claimant, through her attorney, circulated an agreed order providing for a specific date. They didn't ask for an open-ended deadline extension to say, we don't know when she's going to reach maximum medical improvement. So under 44-523F1, she's not at maximum medical improvement now, and we'd like to have this open-ended. The claimant gave herself a date certain to have that case reach regular hearing. And when she was advised that they had not done that, the first thing the claimant did was start circulating additional orders because she knew that she needed the court's blessing to keep the matter open so that those good faith arguments could be heard about, or good cause arguments could be heard about why the case ought to be allowed to survive that. But our point is that this is like the Glaze decision, that those good cause arguments can only survive within either the first 3 years after the filing of the E1 or under the protection of an order that gives the court additional time to consider.
Thank you. Any questions from the panel? Okay, thank you very much. We will take this matter under advisement and get you an opinion out as quickly as possible.